Transferring Ownership, Chapter 2. In Chapter 1, we covered the most traditional and perhaps most common types of real estate transfer, the deed. In this chapter, we will cover several other methods of transferring ownership as follows: testate succession, intestate succession, involuntary alienation. We will review many complex estate planning concepts in this chapter. While licensees are required to be familiar with these concepts for licensing exams, they should not engage in counseling clients regarding their wills or other estate plans. Individuals with estate planning questions should consult competent legal counsel. Testate succession. Testate succession refers to the process of transferring property according to a prepared will upon someone's death. A person dies testate if they die with a prepared will outlining how their property is to be distributed. A person dies intestate if they die without a will. A will is an estate planning tool which conveys title to both real and personal property owned by an individual upon the death of that individual. Property transferred by a will is said to be transferred by devise. Note that the will is only effective upon the death of the individual drafting the will. No interest is transferred until the death of the individual. Assume a dad writes in his will that his home will go to his daughter upon his death. A few years later, the dad decides to sell the home. Does his daughter have a claim to the home or the proceeds to the home that was sold? No. This will does not become effective until Dad's death. If the dad does not own the home referenced in the will at the time of his death, it is impossible for the home to pass to his daughter. The daughter will have no claim because the home was sold prior to the death of the dad. Let's review some vocabulary words associated with wills. A testator is the individual who prepares a will. A devise is a gift of real property through a will. The person receiving the real property is known as the devisee. A bequest is a gift of personal property. A legacy is a gift of money. When a person dies testate, or with a will, the property being transferred by the will is considered to transfer immediately upon the person's death. However, the devisees, or those receiving the real property, will not have full ownership until the will is probated. The process of probate requires the court to confirm the validity of the will, determine what is being transferred by the will, and identify the recipients of the property covered by the will. Probate may take some time depending on the courts with jurisdiction. Creating a will. All states have specific requirements for valid wills. If the will is determined to be invalid in the probate process, the testator's or deceased individual's wishes may not be accomplished regarding the distribution of their property. A testator must be competent or have legal capacity to execute a will. This means the testator is legally old enough to sign a contract. The testator must also have the mental capacity to understand what property they own and understand the identity of their heirs. The drafting of a will must be voluntary. If a third party is able to prove during probate that the testator was subject to undue influence when drafting the will, the courts may find the will to be invalid. If the will is in writing, most states require the will to be witnessed by at least two individuals who are not named as devisees in the will. The witnesses acknowledge that the testator executed the will voluntarily. Some states recognize holographic wills, which are wills written at least in part in the testator's own handwriting. If the signature and the material provisions of the will are in the testator's own handwriting, this may be deemed valid without witnesses. A document intended to modify an existing will is referred to as a codicil. Usually, codicils must be witnessed under the same requirements as the initial will. A testator may alter, revoke, or reinstate their will at any time before their death. Some states prohibit completely disinheriting a spouse. In other words, a will which does not leave anything to the testator's spouse would not be honored. The spouse would be entitled to a minimum amount under state law. In such jurisdictions, a probate court has the authority and obligation to alter non-compliant wills, giving the spouse their minimum share. However, these jurisdictions are becoming more rare. If a married couple held property jointly, the terms of the will regarding the property are irrelevant. If a married couple owns real estate as joint tenants, upon the death of one spouse, the property automatically transfers to the other spouse. Joint tenancy is reviewed in another course.